If a police officer ever asks to see your trunk, understand this. The next 30 seconds can decide whether you stay free or end up facing criminal charges you didn't even know existed. Most people freeze. They think refusing a search makes them look guilty. But the truth is, saying yes too quickly can destroy your case before it ever begins. Here's the conflict. You're pulled over, adrenaline rushing, your heart is pounding, and the officer walks up calmly, then asks, "Mind if I take a look in your trunk?" That moment feels casual, but it's not. It's legal chess. Every word you say triggers a chain of rights, obligations, and evidence rules that will either protect you or destroy you. I'm a lawyer. I've seen cases where ordinary people went from routine stops to felony arrests, all because they misunderstood what consent means under the Fourth Amendment. My job today is to give you the insider's guide, 12 clear, legally sound moves to stay in control when officers want access to your trunk. These aren't tricks. They're grounded in constitutional law, real police procedure, and courtroom realities. Let's start with tip number 1. Tip 1. Know what consent really means. Problem. Most people believe that if a cop asks to search, they have no choice but to say yes. Wrong. Consent is a voluntary waiver of your Fourth Amendment protection against unreasonable searches. The key word is voluntary, but here's what police don't tell you. Anything that sounds like agreement, sure, go ahead, even nodding, counts as consent in court. Once you give it, you've handed them full access to the trunk and anything inside. Even if the search was unfair, it's now legally valid. Solution. Use calm, exact language. Say, "Officer, I do not consent to any searches." Don't argue, don't explain. Just make it clear, on record, that you're invoking your right. Why it works. The moment you state that, the legal standard shifts. The officer now needs probable cause or a warrant to open that trunk. If they proceed anyway, your lawyer can later argue suppression of any evidence found. One simple sentence preserves your entire defense. Tip 2. Understand the difference between a search and a scan problem. Officers often say, "We're just going to take a quick look." That phrase isn't harmless, it's a tactic. A search requires probable cause or consent, but a visual scan or look around sounds informal. So you let your guard down. If you pop your trunk yourself, you've effectively authorized a search. Solution. Never open your trunk yourself. If they have probable cause, they'll open it anyway. And if they don't, they can't force you. Stay seated, keep your hands visible, and repeat calmly, "I do not consent to any searches." Why it works. Legally, your physical act of opening the trunk is strong evidence of consent. By refusing, you prevent officers from reinterpreting your cooperation as permission. Courts give huge weight to your behavior in those few seconds. Tip 3. Learn the automobile exception. Trap problem. Police can search vehicles without a warrant if they have probable cause to believe the vehicle contains evidence of a crime. This is the automobile exception. It's one of the biggest loopholes in Fourth Amendment protection. The idea is that cars are mobile and evidence could disappear, but the scope is limited. They can only search areas logically connected to what they suspect. Solution. If an officer says, "We smell marijuana," or "We think there's stolen property," don't argue, but quietly take note of the exact reason they give. That detail can make or break your case later. Why it works. In court, the officer's stated justification must align with where they searched. If they claim they suspected a stolen phone and still opened your locked trunk, that's excessive and can invalidate the search. Documentation is your armor. Tip 4. Never rely on friendly wording problem. Officers are trained to disarm you verbally. They may say, "Hey, can I just check something real quick?" Or, "Mind if I look in there for my safety?" That tone of casual friendliness is deliberate. It lowers your defenses. You might think refusing sounds rude, but politeness isn't a legal requirement. Solution. Replace emotion with precision. Smile if you must, but answer in full control. "Officer, I don't consent to searches." Then stop talking. Silence is your strength here. Why it works. The law protects your words, not your feelings. Friendly phrasing can't override your rights unless you grant consent. Your calm refusal deprives the officer of the voluntary cooperation narrative they'll later use in court. Tip 5. Don't fall for the dog alert trick. Problem. K9 units can be used to justify trunk searches. If a dog alerts to a scent, that's probable cause, at least in theory. But here's what's hidden. Many alerts are ambiguous or even prompted by handlers. Courts often defer to officers' claims of a dog alert, even if there's no clear video. Solution. If they bring a dog, don't interfere. Just record, if lawful in your state, and observe carefully. Note whether the dog actually sits, barks, or signals. Why it works. Your observation can later expose inconsistencies. If the officer claims an alert but your footage shows none, that undermines probable cause. This is how real cases get thrown out. You can't control the dog, but you can control the record. Tip 6. Keep your body language message neutral. Problem: nervousness is often misread as guilt. Police are trained to interpret physical cues, fidgeting, glancing at the trunk, avoiding eye contact, as reasonable suspicion. Once that threshold is reached, it becomes easier for them to escalate to a search. Solution: practice stillness. Keep your hands visible, avoid sudden moves, and breathe slowly. Your calm demeanor sends one message: control. Why it works. Courts evaluate totality of circumstances. If your behavior appears composed and consistent, it weakens claims of suspicious conduct. You want the officer's body cam to show that you were steady, clear, and respectful. That visual record will protect you more than any argument later. Tip 7. Don't argue about what's inside problem. Many people talk themselves into deeper trouble. When cops ask about the trunk, they say things like, "There's nothing illegal there," or "just tools and clothes." Even innocent statements open the door to deeper suspicion. Every word becomes data they can use to claim probable cause. Solution: say nothing about contents. Just repeat your refusal calmly. If pressed, say, "Officer, I'm not answering questions. Am I free to go?" Why it works. Anything you volunteer, even denials, can legally justify further investigation. The Fifth Amendment protects your silence. Use it. Don't fill the silence with explanations. Fill it with composure. Now let's pause for perspective. Up to this point, we've covered the front-end defense, how to stop an unlawful trunk search before it happens. But there's another half of the equation: what to do if the officer insists, proceeds anyway, or claims authority you can't verify. That's where the next set of tips, 8 through 12, become critical. Before we go there, remember this principle. The body's stress response is automatic. When blue lights flash, your brain floods with cortisol. Your fine motor skills drop, your voice tightens, your reasoning narrows. Police know this. That's why they stay calm. It keeps them in control. But you can override that stress by relying on training. That's what these phrases are: preset responses that protect you when your body wants to panic. This isn't about defiance, it's about control. Control of your rights, your words, and your posture. Because in those tense few minutes beside the road, the calmest person wins. We've talked about how to protect yourself before an unlawful trunk search happens. Now let's deal with the harder reality, when the officer doesn't back off. Maybe they insist, maybe they claim to have authority, maybe they even start opening the trunk anyway. This is the moment when everything you say or do becomes evidence. And your job is simple: stop giving them any ammunition. Let's pick up from where we left off. Tip 8. Don't physically interfere. Ever problem? Your instinct will tell you to protect your property. Maybe you reach for the trunk handle or raise your voice, but here's the danger. The moment you physically block or resist, it's no longer about your Fourth Amendment rights. It becomes about obstruction, resisting, or even assault on an officer. Those are serious criminal charges that erase your legal advantage. Solution: never touch the vehicle once the officer moves to search. Step back slowly, keep your hands visible, and say clearly, "I do not consent to this search." Then remain silent. Why it works. The words preserve your legal position, and your calm behavior removes grounds for escalation. The video footage will later show a clear line. You objected, they proceeded. That's exactly what a defense attorney needs to file a motion to suppress. Tip 9. Understand what probable cause really is. Problem: officers may throw around the term probable cause as if it's unquestionable, but in law, it has a specific definition: a reasonable belief based on objective facts that evidence of a crime is present. It's not a hunch, it's not a feeling, and it's not valid just because you looked nervous. Solution: when an officer says, "We have probable cause," don't argue, but mentally note exactly what facts they cite. Was it a smell, a visible item, a statement you made? Why it works. In court, probable cause must be supported by articulable facts. Vague claims fall apart under scrutiny. If your lawyer can show there was no objective reason, just suspicion, that search can be ruled unconstitutional. Knowing this keeps you focused when they try to intimidate you with legal jargon. Tip 10. Ask, "Am I being detained or am I free to go?" Problem: officers often blur the line between a voluntary interaction and a detention. The law makes a sharp distinction. If you're not detained, you can leave. If you are detained, they must have reasonable suspicion of a specific crime, but most people never clarify it, so the officer controls the narrative. Solution: politely ask, "Am I being detained or am I free to go?" Then stop talking. Don't repeat it, let them answer. Why it works. That question triggers a legal checkpoint. If the officer says you're free to go, walk away calmly. If they say you're detained, every additional minute must be justified later. You've just forced them into accountability mode where time, reason, and body cam evidence all become critical. Tip 11. Know when silence protects you, more than words. Problem: under pressure, people explain, defend, or justify. They think cooperation looks innocent, but the body under stress is chemically wired to overshare. Adrenaline shortens your prefrontal control, so you start filling silence with whatever feels safe. And that's exactly how people incriminate themselves without realizing it. Solution: once you've said, "I don't consent to any searches," stop talking completely. You can even say, "I choose to remain silent." That's a constitutional statement. After that, no matter what's asked, stay silent or request a lawyer. Why it works: silence can't be used as evidence of guilt, but inconsistent words can. Most self-incrimination comes not from confessions, but from contradictions. Tiny details that seem harmless in the moment. Protecting yourself is about discipline, not defiance. Tip 12. Record the encounter within the law problem. Evidence is only as strong as what's provable. Officers have body cams, but you can't always rely on them. Some fail, some malfunction, and some footage mysteriously disappears. If it's legal in your state, your recording could become the most important document in your defense. Solution: keep your phone mounted or recording discreetly. Do not hide it or hold it aggressively. Announce calmly, "For my safety and yours, I'm recording this interaction." Never point it at the officer, just let it capture audio and video. Why it works: your recording preserves tone, timing, and exact language, details that shape courtroom outcomes. If the officer lies about consent, your footage exposes it. If they search after refusal, your video proves the violation. Most judges respect clear, factual evidence over word versus word testimony. Now, these 12 tips are powerful individually, but they're far stronger when you understand the philosophy behind them. The goal isn't to antagonize law enforcement, it's to protect constitutional boundaries that are too often blurred by emotion, fear, and authority. Let's look deeper into the physiology and psychology that drive these encounters. When police approach, your sympathetic nervous system activates, the classic fight-or-flight response. Your heart rate spikes, your breathing shortens, and blood rushes to large muscle groups. Meanwhile, your brain's executive functions, the part that handles logic, memory, and speech, slow down. You literally think less clearly. Officers, on the other hand, are trained to remain calm. Their parasympathetic control is reinforced through repetition and authority. So while your body is screaming, theirs is steady. That's the imbalance. You're emotional. They're procedural. The only way to level that field is with training of your own. Mental scripts, practiced phrases, and internal composure. That's why I emphasize repetition. If you practice saying, "I don't consent to any searches," it stops feeling confrontational. It becomes reflexive. You can speak it evenly, even under pressure. That even tone matters. It keeps officers from escalating while still preserving your rights. Understand this: your rights are not automatic shields. They're tools that must be invoked, preserved, and proven later. The law rewards those who assert calmly and document clearly. It punishes those who argue, resist, or panic. And that's the difference between walking away and facing criminal charges for something as simple as a misunderstanding. Let me give you an example from a real case I handled. A driver was pulled over for a broken taillight. The officer said he smelled marijuana and asked to search the trunk. The driver refused, politely but firmly. The officer opened it anyway and found nothing. The driver stayed calm, recorded the encounter, and repeated his refusal. Later, when the officer tried to justify the search in court, his body cam showed the driver had done nothing suspicious. The judge ruled the search unconstitutional and dismissed the case entirely. That's how it works. You don't need to argue, you need to document. You don't need to win the roadside interaction, you need to survive it legally intact. We've now covered all 12 tactical principles, but in the final section, I'll go beyond the checklist and show you how to integrate these habits into everyday readiness, so that when it really happens, you don't have to think. You'll already be operating like someone who knows the system inside and out. This final part isn't about law, it's about mastery. How to mentally condition yourself so you never let panic or confusion erase your rights again. You now understand the rules, the traps, and the 12 key moves that keep you legally protected. But knowledge alone doesn't save you. Conditioning does. Because the truth is, most people know their rights. They just can't access them when fear takes over. That's why this last part is about mastery, building the mindset and muscle memory of someone who never loses control no matter the pressure. Let's start with this reality. The human brain under threat doesn't think in words, it thinks in instincts. When blue lights flash in your rearview mirror, your limbic system, the emotional center, takes control. It overrides your logic and narrows your focus to immediate survival. What did I do wrong? What's in the trunk? Am I going to jail? That's the same biological mechanism your ancestors used when running from predators. It's automatic. But here's the legal danger. When the stress hormone cortisol spikes, your brain craves resolution. It wants the fear to end now. So you'll do whatever you think will make the officer calm down. Talk too much, hand over too much, agree to too much. And that's exactly how innocent people get trapped. The key is to train your stress response. You can't stop adrenaline, but you can anchor your behavior in rehearsed actions. You don't need to be a lawyer in that moment, you just need to think like one. Start by building your own script loop. You already have the phrases. 1. I don't consent to any searches. 2. Am I being detained or am I free to go? 3. I choose to remain silent. Repeat them out loud. Record yourself. Practice them while calm, because when your body starts to shake, those sentences will come out like muscle memory. It's no different from an athlete running plays or a soldier drilling commands. Your nervous system learns what to do before panic hijacks you. Now let's talk about presence, the physical side of authority. Police read body language the way lawyers read documents. They look for microsignals, eye contact, breathing rhythm, hand movements. Nervous energy, like glancing at the trunk, fiddling with keys, or talking too fast, can feed reasonable suspicion. That phrase alone opens doors you thought were closed. So train your posture. Shoulders back, breathing slow, voice even. Make your stillness deliberate. Not rigid, not aggressive, controlled. The goal isn't dominance, it's composure. You want to radiate one message. I'm calm, I'm respectful, and I know the law. That's the psychological shield that officers recognize instantly. Here's another advanced principle. Never confuse compliance with surrender. Cooperation means following lawful orders. Surrender means forfeiting your rights. There's a difference. If an officer asks you to step out of the car, do it, slowly. That's compliance. But if they ask to search your trunk, you can refuse. That's not disobedience. That's constitutional discipline. The strongest defense comes from knowing where that line is and standing on it quietly. I've seen both sides of this. I've sat across from terrified clients who said yes to everything, thinking it would make the situation go away. And I've defended calm individuals who stood firm and walked away with no charges because they knew what the officer could and couldn't legally do. The difference wasn't luck, it was preparation. Now, some of you watching this are thinking, but won't refusing make me look guilty? That's one of the most common myths I hear. Let me be absolutely clear. Invoking your rights does not create probable cause. It doesn't make you suspicious. It makes you informed. In fact, courts have repeatedly ruled that refusing a search cannot by itself justify further investigation. Officers might act like it does, but legally it doesn't. Here's how you stay grounded when that thought creeps in. Remember that your rights are not emotional. They're structural. They exist independent of your personality, your tone, or the officer's opinion of you. The Constitution isn't polite, it's precise. You don't have to earn your rights by being nice, you just have to assert them clearly. And let's go one step deeper. Every lawful defense begins with documentation. The more factual your behavior, the stronger your case. So after every police encounter, do a quick mental or written record. What time and place did it happen? What reason did the officer give for stopping you? What exact words did you use to refuse? Did they mention probable cause, plain view, or odor? Was there any search? And if so, what areas? These notes don't need to be fancy. They're for your lawyer, not social media. You're preserving evidence while it's still fresh before memory fades or stress distorts details. Those tiny facts, exact phrasing, order of events, tone of voice, can determine whether a judge believes your side of the story. Another essential mindset: never let frustration cloud professionalism. Even if the officer is disrespectful, your calmness becomes a form of self-defense. Anger narrows your credibility. Discipline expands it. You're not just protecting your rights, you're building the record of a reasonable, rational citizen who acted lawfully under pressure. That impression matters when a judge watches the footage. Think of this as 3 levels of defense. First line, your language. Clear refusal, no excess words. Second line, your body. Calm, visible hands, no sudden moves. Third line, your record. Documentation that captures reality. If you hold those 3 lines, you're nearly untouchable from a legal standpoint. The system isn't perfect, but it still responds to evidence, clarity, and composure. Now, let's be brutally honest about the real-world stakes. There are officers who will respect your rights, and there are some who won't. You can't control which kind you'll meet. What you can control is whether your actions protect you in the courtroom, even if they couldn't protect you on the roadside. That's why I tell my clients, the real battle doesn't happen next to the car. It happens later in front of a judge. Your job during the stop is not to win the argument, it's to build the case. Every calm refusal, every recorded phrase, every piece of restraint becomes evidence that you were the professional one. That's how we win in court, by showing the difference between emotion and discipline. Let's bring this all together. The 12 tips you've learned aren't about paranoia, they're about power. Real power. The kind that comes from understanding the system you live under and using it correctly. When police ask to see your trunk, they're not just checking your car, they're testing your boundaries. And every time you respond calmly, you're reinforcing the rule of law itself. That's the mission here. My mission and yours. Because education is the one weapon they can't confiscate. If enough people learn how these encounters truly work, legally, psychologically, biologically, then we remove the fear. We replace panic with preparation. And when citizens know their rights as well as officers know their training, the system begins to balance again. So here's what I want you to take away. Never consent to a search unless you're legally required or presented with a warrant. Always assert your rights with calm, controlled precision. Record or document everything possible within the law. And train yourself to stay composed under stress, because the calmest voice in the encounter holds the most power. If you've made it this far, you're not just a viewer. You're part of a growing community of informed citizens who refuse to be intimidated by ignorance of the law. Share this video with someone you care about, because one day they might be the one hearing those words. Mind if I take a look in your trunk? And now they'll know exactly what to do. Click on one of the cards on your screen to see more videos like this.